Imagine this for a moment. It's a quiet Tuesday morning. Margaret, 74 years old, is sitting at her kitchen table with her second cup of coffee. The mail just arrived. She opens a thick envelope from the county courthouse. Her hands start to shake. The letter says a hearing has been scheduled. Someone has petitioned the court to take control of her finances, her bank accounts, her Social Security, her retirement money, all of it. She didn't do anything wrong. She just had a small stroke 3 months ago. Her memory hasn't been the same since, and now, because she never signed the right papers, a stranger appointed by a judge could soon have the legal authority to sell her home, drain her savings, and decide who she's allowed to see. Margaret sits there frozen. She whispers to herself, "How did this happen? I worked my whole life for this money." If that scenario made your stomach drop, please stay with me, because what I'm about to share could be the most important thing you watch this year. Hello, I am June, your Senior Policy Analyst here at Retirement Tax and Law Pro. For years, I've helped retirees just like you understand the rules that protect or destroy everything you've spent a lifetime building. Today, I'm going to walk you through the 4 accounts that are most exposed when a senior loses their memory or cognitive ability. I'll tell you exactly what the Social Security Administration, the IRS, Medicare, and the Consumer Financial Protection Bureau actually say. And I'll give you the exact forms and steps to lock down each one. Please stay with me until the very end, because there is one hidden mistake that nearly every senior makes, even the careful ones, and it can hand a court complete control over your finances in a matter of weeks. I'll reveal it near the end of this video. You do not want to miss it. Let me tell you about Robert. Robert was 71 years old. A retired postal worker from Ohio. He did everything right, or so he thought. He had a will, he had savings, he had a pension and Social Security coming in like clockwork. He even signed a durable power of attorney at his lawyer's office 10 years ago, naming his oldest son, David, to handle things if anything ever happened to him. Then one winter, Robert was diagnosed with early-stage Alzheimer's. Within 18 months, he could no longer manage his own bills. David thought he was prepared. He had the power of attorney in his briefcase. He walked into his father's bank. He called Social Security. He called Medicare. He called the IRS about Dad's IRA. And one by one, he was told no. Social Security told him a power of attorney is not valid for federal benefits. He needed something called a representative payee, and Robert had never filed for one. Medicare told him they could not even confirm his father's coverage status because Robert had never signed a CMS authorization form. The IRS would not discuss the IRA without a specific federal form, not the state power of attorney. Within 4 months, the family was in probate court. A judge had to appoint a conservator. By the time it was over, more than $30,000 of Robert's savings had gone to attorney fees, court fees, and a professional conservator who didn't even know him. Robert made one small mistake. He assumed one power of attorney would cover everything. It does not. And that one assumption cost his family dearly. Let me explain exactly what the rules say in plain English. There are 4 accounts you must shield before memory loss ever touches your life, and each one has its own separate rules. Your state power of attorney, no matter how well written, does not automatically protect all 4. The first account is your Social Security benefits. Here is what most people don't know. The Social Security Administration's own rules, found in their internal policy manual, state that a power of attorney is not recognized for managing Social Security checks. The U.S. Treasury Department flatly does not accept it. A joint bank account doesn't help either. Neither does being a spouse. The only person Social Security will recognize to manage your benefits if you become incapacitated is what they call a representative payee. And here is the protection you can put in place right now while you are still sharp and clear-headed. It is called Advanced Designation of Representative Payee. It came from the Strengthening Protections for Social Security Beneficiaries Act of 2018. You can log into your My Social Security account at ssa.gov or call them at 1-800-772-1213 and name up to 3 people in priority order who you want to manage your benefits if the day ever comes that you cannot. If you skip this step and you lose capacity, Social Security may suspend your direct deposit while they conduct a capability determination. Then they may appoint someone you've never met, an institutional payee or a court guardian, to receive your checks. Your family will have no legal standing to stop it. The second account is your bank and brokerage accounts. The Consumer Financial Protection Bureau, the federal agency that oversees banks, has issued very clear guidance on this. They recommend 3 protections. First, a durable financial power of attorney properly drafted under your state's law. Second, a trusted contact person on file with your bank. Third, duplicate statements going to a trusted relative. Now here's the trap so many seniors fall into. They try to make things easier by adding an adult child as a joint owner on their checking account. Please, please listen to me. This is one of the most dangerous moves you can make. The moment you add your child as a joint owner, every dollar in that account is legally exposed to that child's creditors, that child's divorce, and that child's lawsuits. If your son gets sued or your daughter goes through a divorce, your retirement savings could be on the chopping block. And on top of that, it can disqualify you from Medicaid for up to 5 years if you ever need nursing home care. A trusted contact is completely different. A trusted contact does not have access to your money. The CFPB is crystal clear on this. A trusted contact only gets notified if the bank sees signs that something is wrong. That is exactly what you want. Without a proper durable power of attorney, if you lose capacity, no one can legally touch your bank account. Not your spouse, not your children. The bank will freeze it. And the only path forward is a court conservatorship, where a judge can appoint a professional conservator, often a complete stranger, who is paid hourly out of your own money to manage your accounts. The third account is your retirement money, your IRA, your 401k, your pension. This one shocks most people. The IRS does not honor your state power of attorney for federal tax matters. They require their own form. It's called Form 2848. And there's a second form, Form 56, which notifies the IRS that someone is acting as a fiduciary on your behalf. So even if you have a beautifully drafted state power of attorney, when your son or daughter calls the IRS to handle a tax issue with your IRA, the IRS can refuse to speak with them until those federal forms are on file. And here is another quiet danger: required minimum distributions. If you are 73 or older, you must take a required minimum distribution from your traditional IRA or 401k every single year. If you lose capacity and that withdrawal gets missed, the IRS charges an excise tax of 25% on the amount you should have taken. That can be reduced to 10% if corrected quickly, but it's still painful. Please also remember this: the beneficiary you named on your IRA or 401k form overrides anything in your will. Look at those beneficiary designations today. Make sure they are current. If your ex-spouse is still listed because you never updated it, your ex-spouse will get the money, period. The fourth account is your Medicare and health insurance account. This one breaks families apart every single day. Medicare, by federal law, cannot discuss your account with anyone, not even your spouse of 50 years, unless you have filed the proper authorization. You need to file CMS Form 10106 to give Medicare permission to share information with a loved one. And if there is ever a coverage denial or an appeal, you'll need CMS Form 1696 to appoint a representative for that appeal. Without these forms, the 1-800 Medicare representatives are legally prohibited from talking to your daughter, your son, your spouse, anyone. They cannot fix a billing error. They cannot appeal a denial. And Medicare appeal deadlines are short, often just 120 days. Miss the deadline and the denial becomes permanent. Now I want to share with you exactly what to do. 3 clear steps. Do these this week if you can. Step 1. Go to ssa.gov, log into your My Social Security account, and complete the advanced designation of representative payee. Name up to 3 trusted people in priority order. If you cannot do it online, call Social Security at 1-800-772-1213 and ask them to walk you through it. This is free and it takes about 15 minutes. Step 2. Make an appointment with a qualified elder law attorney in your state. I know that sounds expensive, but it is far cheaper than a conservatorship. Ask for a comprehensive package: a durable financial power of attorney with specific retirement account language, a healthcare power of attorney, a living will, and a HIPAA authorization. While you are at it, file IRS Form 2848 naming someone for federal tax matters, and complete CMS Form 10106 for Medicare. Also, call your bank and your brokerage and ask to add a trusted contact person to every account. Step 3. Keep copies of every single document in one organized folder. Tell at least 2 trusted family members where that folder is located. Update your beneficiary designations on every IRA, 401k, pension, and life insurance policy. Review them once a year on your birthday so you never forget. Now, I promised you the hidden mistake near the end of this video. Here it is. Please listen carefully. The biggest mistake seniors make is assuming that one single power of attorney signed at a lawyer's office covers everything. It does not. Social Security needs its own designation. Medicare needs its own form. The IRS needs its own form. Your bank wants its own internal documentation. Each federal agency has its own rules, and they do not honor each other's paperwork automatically. If you only have one state power of attorney and nothing else, your family will hit a brick wall the moment your memory fails. They will be forced into probate court, a judge will appoint a conservator, and under what's called a full or plenary conservatorship, that conservator can take legal control of nearly everything: your money, your home, even who you are allowed to see. AARP has documented case after case where seniors were isolated from their own families by court-appointed conservators. This is not a scare tactic. This is what is happening right now in courthouses all across America. Please do not put this off. Memory loss does not send a warning letter. A stroke does not give you 2 weeks' notice. The time to sign these documents is while you are clear-headed, calm, and in control. Once you lose capacity, it is too late. The court takes over. And please do not rely on YouTube notifications or social media to remind you about important changes to your benefits. Algorithms change. Videos get buried. Government rules update quietly without headlines. Bookmark the official sources: SSA.gov, Medicare.gov, IRS.gov, and consumerfinance.gov. Check them at least twice a year. And if you have a trusted attorney or financial advisor, schedule an annual review. If this video helped you, please share it with someone you love: a spouse, a sibling, a friend at church, a neighbor. You may be the reason their family avoids a court battle they never saw coming. This is June, signing off from Retirement Tax and Law Pro. Take care of yourself. Protect what you've built. And I'll see you in the next one.